I'd like to welcome everybody to our annual government contracts update. This year is exciting because we are also live streaming as a webinar. So I wanted to, at the outset, give everyone a warning that this is going to be recorded and people are hearing it. My name is Erin Toomey. I'm a partner at Foley and Lardner in our Detroit office, and my specialty is government contracts. For those who are on the webinar, you know that you have the ability to type in some notes, and we have someone in the room who will be looking at those notes and comments. If you're having trouble hearing, there's a lot of background noise, please let us know and we'll do what we can to correct it. So everyone can please bear with us because there'll be some things that are unique to the folks who are on the phone and some for those in the room. We are going to have some question and answer periods today, and when we do, those on the phone can type those in, and Anna Ross from our DC office is here to read those out loud. And for those of you in the room who ask questions, I'll repeat the question into the microphone so those on the phone can hear it. Let me tell you a little bit about Foley because they sponsor this event, and we have to get our little plug in for Foley. So Foley is a national law firm. We now have about 17 offices in the United States, and we have offices in Brussels, Tokyo, and Shanghai as well. Across the firm, we have about 850 lawyers. We don't all do government contracts. We do a variety of legal work ranging business, intellectual property, litigation, healthcare, white collar, you name it, I think we have it. A big employment practice. In particular, I love it when someone has a really strange question and they send an email around to the whole firm and says, who knows something about this? Or who has experience in this? And within minutes, you get an email. I just dealt with that last week, so it's fantastic. We have several Foley attorneys in the office, or in the audience today. So during our breaks and during the lunch, please introduce yourselves and network among yourselves. This is also always a great opportunity to network with other government contractors in the area. I don't think we have enough opportunities to all get together and talk about the issues that we're jointly facing. There's some housekeeping matters I need to get through. For those of you in the room, if you want CLE credit, continuing legal education credit, there is a form at the desk where you signed in that you need to sign up for. For those on the phone, I need to read something. Today's program will run for 2.5 hours of instruction time, and we will apply for 2.5 general CLE credits. Anyone wishing to receive credit for today's program via the webinar must enter the codes when announced. So for those in the webinar, not those in person, a box to enter these codes will appear on your screen for approximately 30 seconds at different intervals during the presentation. Everyone seeking CLE credit must enter this code in the box on the screen at that time. All New York, New Jersey, and Kansas attendees applying for CLE credit must also fill out an attorney affirmation form and write down the course code. The attorney affirmation form and a copy of today's slides can be obtained in the resource list widget at the bottom of your screen. For New York attorneys, those of you with less than 2 years of experience will not be eligible for CLE today. Completed attorney affirmation forms should be sent to Christina Wade at cwade, W-A-D-E, at foley.com. CLE certificates will be sent to eligible attendees via email in approximately 8 weeks. For those attending via the webinar, as I mentioned, you could type questions in when the questions come up. So, again, for those in the webinar, to get the CLE credit, you need to type in the codes when you see them. So today's format, we are going to have 3 presentations. The first 2 will run for about 45 minutes each, and the last one may be closer to an hour. When we do the presentations after each one, we're going to have a separate Q&A. The topics were separate enough that I thought that made more sense this year rather than just having one Q&A before the break. We are going to break after the first 2 presentations, but the food in the room is only here for another half hour or so, so feel free, continuously get up, get something to drink, get something to eat. You will not disturb us if you do so. Everybody has a book in front of you. In the book are the slides that we'll be going through today. Behind tab 5 is a list of acronyms that are used in the slides. So if you feel like you got lost and you need to refer to what the acronym means, use that. It is not all the acronyms in government contracts. I don't think we could have a book that would hold all of those. Tab 6 has the bios for myself and Jennifer Belveal, who will be speaking today. So we're not going to do grand introductions of ourselves. If you want to read about us, feel free to flip to the bio. Also, on that table over there, there are a bunch of handouts. And all of the handouts that are there are also available, linked to either my bio or some of my colleagues' bios for those of you on the webinar. We have a series of practical law articles that me and my colleagues have written on topics such as commercial item contracting, bid protests, teaming agreements, government contracts, diligence, and mergers and acquisitions. And then for those who are relatively new to government contracting, a general government contracting overview. We also have one on GSA multiple award schedule contracts. So feel free to pick those up. If we run out, if there's any that you want, let us know, and we can get it to you. Critique sheets. All of you in your booklets have a yellow critique sheet as well, and for those of you who are on the webinar, at the end of the webinar, there'll be a survey. Please give us feedback, especially this is new for us doing the webinar, and I love the ability to reach those who are not in Michigan because we have a lot of clients and contacts and colleagues outside of Michigan who benefit from these topics as well. But let us know if this is a good format and if it worked and if there's topics you want to hear us address next year. A lot of the topics we choose are based on that feedback. So I think without further ado, we will get started. Oh, and please mute your cell phones. Okay, so first today we're going to talk about DCAA, Defense Contract Audit Agency audits. I chose this topic this year because there's been a lot of movement in this area, and it has been an area of significant litigation as well, so I thought it would be worthwhile to update those in the room and on the phone. So a little bit about DCAA in case you are not too familiar with them. They provide audit and financial advisory services to the Department of Defense and other federal agencies. I think some people don't realize that they are an assist agency for those even not in DoD. They audits for civilian agencies, in fact, traditionally represent about 9 to 11% of their budget. That's $50 to $64 million in funding. They operate under the authority, direction, and control of the Undersecretary of Defense. And in fiscal year 2015, DCAA had about 4,800 employees. Interesting statistic, about 27% of those are CPAs. They examined $257 billion in contract costs. They issued over 4,500 audit reports, and they were able to reduce the time it took to conduct an incurred cost audit from an average of 1,000 days in fiscal year 2014 to about 880 days in fiscal year 2015. Now, although that's a significant reduction, that's over 2 years it takes them to perform one incurred cost audit. And if we have auditors in the room, I'm sorry. And in fiscal year 2015, they closed out about 4,500 audits, but only 1,900 of those were incurred cost audits. When DCAA performs these audits, they do so in accordance with their contract audit manual. I just saw something on their website that says they're not going to print it in hard copy for us anymore. We actually have to go to their website for it. They also issue additional audit guidance that is not available on the website. But if you have an auditor who's going to come to your facility, you want to kind of know what their procedures are that they're following, the types of documents they'll be looking at, or if you want to push back for any reason on their audit, the CAM is a good reference. And I think I'm a little old school. I still refer to it as the DCAM, but DCAA refers to it as the CAM. DCAA only makes recommendations. They are not the decision-making authority, and I think that's a lot of my clients don't realize that. They're very scared of DCAA, but who you should make sure your best friend is your cognizant contracting officer, whether that's the administrative contracting officer at DCMA, whoever the contracting officer is who's responsible for really determining after DCAA gives their audit report, they look at the audit report and they decide how to act on it. So obviously you want to have a favorable audit report, but they are not the ultimate decision maker. In fact, the sustainment rate in question costs in fiscal year 2015 was about 50%. So that means out of the costs that DCAA questioned, contracting officers acted on about 50% of those. And I have an example up here. So let's say DCAA recommends that you get a penalty assessed because you had clearly unallowable costs in your incurred cost submission. They make that recommendation to the ACO or DCMA. It was really up to that ACO as to whether or not they act on it. I have on the next few slides some examples of audits for those of you who are not familiar with the different types of audits DCAA may perform. If you are going to get a cost reimbursement type contract, you need to have a DCAA approved accounting system. So they will do a pre-award accounting system survey. If they, for some reason, don't think you're high risk and they don't do a pre-award, they also might do a post-award, or they also might follow up post-award if pre-award you had some issues and they want to make sure that you've implemented the fixes. They also do proposal audits. These are most likely when you have a fixed price contract and you've provided certified cost or pricing data. They might look at that to determine the feasibility and assess the proposed cost in a proposal. DCAA also conducts audits of certified cost or pricing data post-award. So this is when they can audit up to 3 years after final payment. They all of a sudden look at your cost or pricing data and they assess whether or not what you disclosed was current, accurate, and complete in accordance with your certification. They also might do timesheet checks. They want to know that, especially if you have a labor hour, time and material type contract, or cost reimbursement contract, that you have a solid way for accounting for your employee time, that managers or supervisors are signing off on it. Timesheet is now oftentimes electronic, and that's okay. Not quite sure if DCAM has caught up to that fact yet, but they're getting there. Contract financing, so if you're getting progress payments. When you get progress payments on a fixed price contract, it essentially turns your payment request into a cost type contract. You only get paid for costs that you've incurred and show you've incurred. So they might audit those, make sure that the payments are valid, that the government should make the payments claimed. Provisional billing rates. So if you have a cost reimbursement type contract and at the outset of the year, you go to the government and you say, these are what we think our indirect rates will be for the year. Those are your provisional billing rates. Once DCAA audits them, your contracting officer signs off on them. That is what you then use to bill on base throughout the year. And then after you submit your final incurred cost submission, DCAA audits again, you come up with a reconciliation, and that's the process. And then finally, your incurred cost submission. So those are your actual indirect rates that you submit by June 30th of every year, saying what your actual experience was as opposed to your anticipated experience in your provisional rates. So typically, if you want to kind of differentiate fixed price versus cost reimbursement contracts, the pre-award audits are more focused on the fixed price contracts, and the post-award audits tend to be more focused on the cost reimbursement type contracts. DCAA also conducts audits with task-covered contractors. So those are contractors subject to the cost accounting standards. They will audit your disclosure statement and make sure it's adequately capturing your cost accounting practices. Also, if you have a change in your accounting practices and you submit a impact statement to the government saying how that will impact the government's costs, they will audit that to confirm that it is accurate. And then last, DCAA in recent years got another responsibility, and that is to audit your business systems, your accounting, earned value management, estimating, purchasing, material management and counting, and property systems. Again, these are for CAS-covered contractors, but it is important to think about how this expanded DCAA's role. Previously, we think of them as more financial focused in their audits, but let's take, for example, purchasing audit. When they do their purchasing audits, they look at if you're issuing commercial item subcontracts under a non-commercial item prime contract. Are you justified in doing so? Do you have a commercial item justification? Are the goods or services, do they qualify as commercial items? I don't really know if DCAA is qualified to make those judgments. I know when I help clients put those together, there's a very technical aspect to it. What are the similarities between what you're providing to the government and what you provide commercially? What are the differences? I'm on the phone with the engineers. We're talking through it all. I'm not sure if DCAA is really the folks who are qualified to make some of those assessments. So some of the concerns that industry has had with expanding DCAA's role in these areas is that it's kind of pushing them outside the bounds of their comfort zone, and I think they sometimes, based on the lack of understanding, question things that really are proper and appropriate, and it forces the contractor then to have to defend them. So what is the audit process? Everyone loves to get that letter from DCAA saying that they've been requested by the contracting officer to perform an audit. And let me also make one statement. It's not just prime contractors who get audited. Subcontractors do as well. So if you're sitting there saying, I don't need to worry about this, I'm just a subcontractor, I'm not a prime. Nope. You will be audited too if you fall into any of these categories. Now, if you're only performing fixed price commercial item contracts, you probably won't see DCAA very much. But if you're performing other types of contracts, DCAA becomes your best friend, or worst enemy, just depends. So the audit process is the contracting officer or administrative contracting officer requests that DCAA perform the audit. You then get a letter from DCAA saying that they're going to perform an audit, and they mention the scope of the audit, and then they usually tell you a kind of initial set of documents or information that they'd like for you to gather for them. After some exchanges, maybe they ask for documents in advance, maybe they prefer to have the on-site interview, they come to your facility and you have a meeting with them, and sometimes they're at your facility for quite some time. Sometimes they're housed there a day, 2 days, sometimes weeks, months, years. The major government contractors actually tend to have auditors kind of stationed at their facilities. So after DCAA is on site, excuse me, they get a bunch of documents from you. They will then often follow up with some questions. Obviously, it takes them some time to take a look at it, to review it, to go through it. And they'll come back to you with some additional questions, requests for information. They then will conduct an exit conference where they'll discuss their audit findings. They'll provide you with a draft audit report. And then as a contractor, you have an opportunity to comment on the audit report. And if there are things in there that you do not agree with, you want to make sure that you submit written comments that then can get incorporated in the final audit report. When DCAA issues their final report, they're not always good about providing the contractor with a copy of it. So make sure to follow up with them and try to get a copy of that. A lot of times I ask people when I'm working with them, whether it's through due diligence in a merger and acquisition, give me a copy of the audit report. So, well, we never got one, but trust us, they said we were fine. It doesn't go over very well. And then after DCAA issues that final audit report, they then obviously send it to the contracting officer, and it's up to the contracting officer to decide whether or not to act on it by submitting a claim to contracting or a claim to the contractor, especially if the government thinks they're owed money. What access to records does DCAA have? Heads of all executive agencies have broad authority to inspect plants and audit records of contractors that are performing cost-type contracts. And these agencies are authorized to examine, quote-unquote, all records relating to a contractor's proposal and the contract when you're providing certified cost or pricing data. DCAA has subpoena power. They have the ability to subpoena records. So knowing that, it is always better to cooperate in advance than wait for that subpoena to come in. Although, as we discussed, there may be some times where you do really need to push back on records. One of those times is attorney-client privilege documents. So as you're thinking about what it is you do and do not want to give to DCAA, the correspondence that you have either with inside counsel or outside counsel about whether or not you think certain costs are allowable, don't give those to the auditor because that waives your privilege. However, if you do push back on DCAA, you might walk into a denial of access issue. DCAA may determine it can't evaluate certain costs, and it will cause them to question all costs potentially if you deny them access to certain records. And so this could result in some litigation down the road as to contracting officer disallowing certain costs and you having to litigate over it. But what about certain documents? Internal audit reports, internal investigations, compliance reviews. We are seeing DCAA request these types of documents more and more, especially in conjunction with those business system audits. What about the Contractor Code of Business Ethics and Compliance Clause, FAR 52203-13? If they want to audit compliance with that, they might want to see, well, where's your code of conduct? Where's your internal control system? Where's your business ethics and awareness program? Let's see the reports that have come in and how you responded to them. Well, wait a second. Then we're really getting into dicey territory there. So in the Newport News cases in the 1988 timeframe, they held that documents containing internal auditor subjective evaluations are not within DCAA's subpoena power. These were a series of 2 cases in which DCAA was really trying to get at some internal audit reports. However, documents that contain objective factual records relating to the accuracy of costs charged to the government are within their subpoena power. So it seems like they've tried to distinguish between what is subjective versus what's objective fact. And that's true. I mean, under the attorney-client privilege, the facts, underlying facts are not privileged. It's the advice relating to those facts that's privileged. So it's not always 100% clear, though, in black and white as to what is and is not covered. Section 832 of the 2013 National Defense Authorization Act said that when DCAA seeks access to internal audit reports, there are some criteria they first must meet. So this was in reaction to the Newport News cases. The National Defense Authorization Act issued some new rules to provide some more guidance to DCAA on when they can have access to these internal audit reports. They need to provide a written determination that access to the report is necessary to complete the required evaluation of a contractor business system. Again, that was the guise under which it's requested. How is your business system? We need to see what your internal audit reports say in order to know if you're properly performing internal audits. It's a little dicey. A copy of the request from DCAA for access to the reports and a record of the response received from the contractor, including the rationale if access was not granted. So they need to get all of that documentation together. DCAA guidance issued in April of 2013 allowed access to internal audit reports, again, for business system reviews, and also to assess the effectiveness of internal control systems. However, DCAA needs to demonstrate a nexus between the requested report and the risk assessment procedures in the audit. I would think that's probably fairly easy to show. As I said, I need to know how good and robust their audit procedures are by looking at their audit reports they issue. I don't think contractors are going to like that very much. What about access to employees? Do you want DCAA to come in and walk your facility and just randomly interview employees? No, you don't. Does DCAA have access to your employees, though, for sit-down interviews? There's actually no statutory, regulatory, or contractual authority for DCAA to conduct these interviews. In July 2013, again, DCAA issued guidance. They encouraged auditors to interview contractor employees, especially when they have a hint of fraud. Well, wait a second. We went from CPAs looking at financial information to now auditors investigating fraud. They're not trained investigators. They're not criminal investigative agents like we have in the government. So this also raises concern because can these auditors really tell the difference between an honest mistake, a misunderstanding of the regulations, which we always know are crystal clear, or do they just jump to, well, it's fraud because everyone should know this because we, DCAA, know the cost principles inside out, upside down. We live, eat, and breathe it. So the fact that you didn't get it means it's fraud. I have a lot of clients and contractors and contacts who have cost reimbursement contracts and don't understand the cost liability principles inside and out. Trust me. It's not fraud. So what are some best practices with respect to contract performance and knowing that you have a contract that might get audited? The key is to retain all documents relating to auditable contracts. FAR Subpart 4.7 talks about document retention timeframe. The government actually, in January 2016, DOD, NASA, and GSA, they actually revised their contract retention file policies for internal government purposes to say that for contracts both above and below the simplified acquisition threshold, the government's going to keep those documents for up to 6 years after final payment. Trust me, you don't want the government to be keeping their documents and for you not to have your documents, right? Because then if there's only one set of documents, their documents are going to control. Right now, the audit clause only requires you to keep documents for up to 3 years after final payment, or if there's a longer period specified in FAR Subpart 4.7. So the other issue is FAR 31.201-2D, says, I read, a contractor is responsible for accounting for costs appropriately and for maintaining records, including supporting documentation, adequate to demonstrate that cost claims have been incurred, are allowable to the contract, and comply with appropriate cost principles. The contracting officer may disallow all or part of a claim cost that is inadequately supported. So, you do not have your documents to show that a cost was incurred. You do not have the documentation with the contracting officer where they agree that the cost was allowable under your contract. They will potentially disallow your cost, even if it was completely valid. So documentation and document retention is key. Now, I know there is a cost associated with document retention, especially with data and how large it is. There's a lot of storage costs. So what does that mean? It encourages you to close out your contracts. Try to push the government, try to push your prime contractors to get some closure, to get some closeout, because these time periods run from the date a contract is closed. This causes a lot of problems for the cost reimbursement contracts, where the incurred cost audits are significantly delayed, as we'll be talking about. So there's just a bunch of issues surrounding DCAA's delays and these lingering contracts that remain open. During an audit, what are some of the best practices? Make sure that you appoint one person from your organization, preferably who's trained in government contracts and audit procedures, to be the sole point of contact for all communications with the auditor. So you want to make sure they're the point of contact via email as well as in person when they come to the facility. What does that do? That makes sure that you do not have issues with one person saying one thing, another person saying something contradictory. Again, that might start to take off their fraud indicator, even though it just might be a misunderstanding. Make sure, too, that that person doesn't talk to things unless they know what they're talking about. It's okay to say to the auditor, I don't know, let me go check. Let me go get that information for you. I'm not the right person for that, but I will get it for you. That point of contact for DCAA likely won't be the right person. You'll probably need information from purchasing, from sales, from finance, maybe HR if you're talking about timesheets. So they're not supposed to know everything. They're just supposed to be the primary conduit through which information is fed to DCAA. You want to be fully responsive to the audit request because, again, otherwise you can get access to records issue or DCAA will issue a subpoena. You can, however, negotiate reasonable limitations on what DCAA is requesting. So don't give them unfettered access to your file room. Hey, here's our room with a bunch of boxes. Have at it. Don't let them log into your computer system as you and just start looking at files. You don't want to do any of that. You want to make sure it's very measured in terms of what they're asking for. If they're asking for all timesheets for an entire year period, why don't you suggest a sampling? How about DCAA, you give us a random sampling. What weeks do you want in the year? You choose a sample. We'll give it to you because it's really burdensome for us to pull timesheets for the entire year for everybody. You also want to keep copies of everything that you give to DCAA. If there's any ever question, some of these audit reports take about a year to get issued after the audit went on for a year. It takes the contracting officer another year or two to act on it. Who knows if your employee who had that primary contact with the auditor is still there and remembers what was given. So keep a nice, pretty audit file together. And when DCAA is asking you questions, ask them to put them in writing. I often get clients to get the question in writing from the auditor. They send it to me. I see the client's first take at what they're going to say to the auditor, and I say, no, don't say that. And we help them revise it. That gives you a chance to think about it, to give supporting documentation, to put forth the right response, as opposed to just an off-the-cuff answer on the phone, which could be misinterpreted. And then you're left with each party's recollection of what was actually said, and that's not helpful. In terms of interviews, as I mentioned, if they want to talk to employees, maybe they do want to talk to the person in purchasing because it's really inefficient for you to have to bring the person in, get a question from DCA, go to purchasing, come back. Get another question, go to purchasing, come back. You don't need to have a monkey in the middle there. So you can have them talk to other employees, but make sure that that primary liaison with DCAA is in the room. They want to be taking notes. They want to know what's being said. These are not privileged discussions. Even if you have a lawyer in the room, it's not a privileged discussion. So they need to be properly prepped in how to talk to an auditor. How if they're not sure about something, they could say, I don't know, I need to look into that. And that's a helpful practice. Post-audit, you will be getting, as I mentioned, the draft audit report. If there's any misrepresentations in there, you want to respond to those in writing. Again, feel free to have legal counsel or any accounting consultants that you use take a look at those in advance because those will be going to the contracting officer. They will see that. So when the contracting officer is trying to assess, do we make a claim, do we not, they're going to take into account your response. You want it to be well thought out. If the audit report says there are some things that they found that are wrong that you agree with, implement your corrective action because if DCAA comes back a year later and you still have the same problems, they're probably not going to be so nice about it, especially the contracting officer. So if you didn't understand a certain cost was unallowable, maybe you disagreed with the auditor said it was unallowable, you're not going to fight about it. If you're then treating it as allowable the following year, then you might start getting the penalties assessed. So this was a very interesting year. Because of DCAA's audit backlog, Section 893 of the National Defense Authorization Act said, effective November 25th of 2015, DCAA auditors could no longer provide audit support to non-defense agencies. DCAA has kind of put their own interpretation on that, so if they're doing incurred costs review and you have both DoD and non-DoD contracts, they're still going to do that for you. However, this really stopped in the tracks audits that were already started with non-defense agencies, which have now been in a holding pattern. This has also placed enormous financial pressure on DCAA. As we said, they have a set budget, but they get $50 to $64 million in funding every year from these non-defense audits that now they're not getting in. But the focus and the purpose behind it is we want you to focus on cleaning up the defense backlog before you're helping all of these other agencies. And so they said until the backlog for incurred cost audits is less than 18 months of incurred cost inventory, this is how it's going to be. So we are now into a new government fiscal year. We'll see what the next National Defense Authorization Act says, if this continues. But I know contractors who have contracts with non-DoD agencies are really frustrated with these audits that are stalled because they don't know, are they going to restart, are they not? Those agencies also have incurred cost proposals that are still open, sometimes back to 2003 or further. That's very difficult for companies to have that much uncertainty, especially when we're looking in the merger and acquisition context. If you're looking at acquiring a company that has that much of an open backlog, that's a little scary. You don't know what kind of risk you're buying. Also, given these backlogs, it's important in those acquisition documents to clearly set forth who is responsible for those costs. Look, the government might come back and say, you know what, I think you made a mistake. We owe you a lot of money. It doesn't really happen very often, so it's more usually in the other direction. If DCAA doesn't listen to this guidance and does help non-defense agencies, their budget is going to be reduced in an amount equivalent to what those reimbursements are. So the DCAA was significantly disincentivized to help non-DoD agencies. Also, the National Defense Authorization Act wanted to improve auditing and contracts. They want DCAA to report on the percentage of question costs that are sustained or recovered by the government. And they also want to implement efforts to avoid duplicative audits and to streamline oversight of reviews. This has really prompted an increased use of the quick closeout procedures, so I wanted to mention those in case you're not familiar with them. FAR 42.708 says that a contracting officer shall negotiate the settlement of direct and indirect costs on a contract in advance of final and direct rates being determined if certain factors are in place. The first is that the contract is physically complete. The next is the amount of unsettled direct and indirect costs is relatively insignificant. What does that mean? It's the lesser of $1 million or 10% of the total contract value. The contracting officer then performs a risk assessment. If they don't think it's too risky, they can go ahead and close out your contract. So you don't yet have final and direct rates, but you can actually get that contract closeout. And that's important because that is when the time frame for audit really starts to run. And also they do it if they can reach an agreement on the estimate of allocable dollars. So we're seeing an increase in the government's use of these quick closeout procedures. And this is supported by DCMA's class deviation issued in September 2015 that broadened the scope of the ability to use these quick closeout procedures a little bit further because it said regardless of the dollar value or percentage of the unsettled direct or indirect costs. So before we had that 1 million or 10% standard, they said regardless of that. So they really are encouraging close out these contracts, reduce the backlog, again, if you think the risk is minimal. Currently, this is in effect until September 30th, 2017, or unless it's otherwise rescinded. So what does this happen? This really, with DCAA's backlog and the delays in the issuance of audit reports and the delay between the audit report and the contracting officer decision, there's really been a perfect storm that's been brewing. And so what happens is under the Contract Disputes Act, for contracts awarded after October 1st of 95. It requires the submission of a contract claim within 6 years after the accrual of the claim. Well, what's a claim? That's your contracting officer's final decision. It's not the audit report. That's not a claim. The contracting officer's final decision, and it has to be done within 6 years of the accrual of the claim. So that creates a question, well, when do these claims accrue? And so we've seen a lot of cases recently about when does a claim accrue, and contractors trying to use the Contract Disputes Act, which traditionally is thought of as contractors a claim, we have to submit it in 6 years, we're going to be banned. It's been turned on its head and really been applied strictly against the government. Government, you haven't audited my 2003 incurred cost proposal. I gave it to you in 2004. You've had it. You've been sitting on it. Just because you now get around to audit it doesn't mean I owe you anything. And so I've seen contractors using this argument in their responses to audit reports and in responses to contracting officers' question costs, which is, okay, government, you know, I see that you say it's expressly unallowable, but if you weren't beyond the statute of limitations, you know, maybe we would have paid it, but you're beyond it. And it at least gives you some room to negotiate. So we'll talk about some of these cases. The first is the Raytheon Space and Airborne System case from April of 2013. It was an Armed Service Board of Contract Appeals case. And in this case, the government claim accrued well, first of all, let me talk about when a claim accrues. A claim accrues when all events that fix the alleged liability and permit association of the claim are known or should have been known and some injury has occurred. So it's a known or should have been known standard. In this case, the issue was, when did the government know or reasonably should have known that it had a basis to seek a cost adjustment to the contract? And this had to do with a cost accounting standard disclosure statement and a change in the accounting practices by the contractor. The government claim, the board said, accrues when the government knows or has reason to know that some injury has occurred, even if the amount has not yet been finalized or some more complete analysis will follow. So they looked at various cost accounting changes that occurred, and for each change, Raytheon differed in how quickly it gave the government the cost impact. So sometimes it said, government, we had this cost accounting change, we'll come back to you with the cost impact. Sometimes, along with the cost accounting change, pretty much simultaneously, they gave the cost impact. And really what the board ended up saying is that it really comes from when the government had the cost impact information. Because just telling them you have a cost accounting change doesn't tell the government whether or not they have a claim. So the claim accrues enough to trigger the statute of limitations when they're aware of the cost impact. Now, that is the case even if the amount has not yet been finalized, or if there's more analysis that will follow. So if you say to the government, you know, based on our preliminary calculations, we think it's going to be $100,000 more a year to you, but we're doing additional analysis and we'll get back to you. It's that first notice that runs the statute of limitations based on this case. Raytheon seems to have a lot of these cases. Then there is the Raytheon Missile Systems case in January 2013. In this case, there was a class disclosure statement notice given in late 98 that effective January of 99, major subcontracts would receive a lower burden rate. Well, at the same time, in September 2006, there was a DCAA audit report that was issued that challenged Raytheon's application of that reduced burden rate on a 1999 subcontract with Lockheed Martin. So essentially, Raytheon did not treat that subcontract with Lockheed Martin as a major subcontract and therefore had the full burden rate. And the government argued no, they should have had the reduced burden rate. The contracting officer issued a claim in 2011 that Raytheon failed to follow its revised CAS accounting disclosure and in terms of not treating them as a major subcontractor. They sought $10 million plus $6.8 million in interest back from Raytheon. The government said, or the board said, that accrual of a contracting party's claim is not suspended until it performs an audit or other financial analysis to determine the amount of its damages. A single party cannot postpone unilaterally and indefinitely the running of the statute of limitations. Great case for contractors, because their argument was not only is it, well, we have to do our audit of your statement about the impact before we owe you anything, contractor, or before we have to submit our claim. They said, no, you don't have to wait for DCAA. They can run that forever, and we see that they are. That's not fair to the contractor. Not only that, but there's a discrepancy between who the notice was given to, which was the administrative contracting officer, about the accounting change. And then it was the price analysis who performed the audit in 2006. And they said, well, it needs to be the ACO needs both information. And it was different people, and the board rejected that argument too. It's the government. You gave it to the information, people responsible in the government. I know the government sometimes likes to be big government with a capital G. Sometimes they like to say, well, we're all very different, and you have to tell different people in order to have proper notice. In this case, they said no. It doesn't wait to accrue until the information is transmitted to whoever it is the government decides the information should be transmitted to. And then in 2015, we had the Alliance Science and Tech Corporation case, another board case. In this case, there was an appeal of a final decision asserting a $338,000 claim seeking penalties for including expressly unallowable costs in an incurred cost submission for fiscal year 2005. The incurred cost submission was submitted on March 31st of 2006, but it was missing schedules. So there was some amendment and some resubmission. Some additional information was provided at various time frames. DCAA issued an audit report in April 2012. The government issued a final decision on August 21st of 2013. And that final decision asserted penalties due to the inclusion of expressly unallowable costs in the 2015 incurred cost submission. The board looked at whether it was reasonably known from its proposal that it included specific costs that the government claims were unallowable. And what the board said, that it was an issue of material fact. It wasn't a basis to dismiss whether or not the proposal, based on the incurred cost submission alone, you could tell that these were expressly unallowable costs. And so this creates the issue of, first of all, if you need to resubmit your incurred cost submission for any reason because your documentation was not good, there's something wrong with it, you are restarting that statute of limitations. Keep that in mind, okay? So if you have incurred cost submissions going back 5 years, 10 years, you decide that, you know what, we always forgot to include this schedule, we're going to resubmit them all, then it's all fair game. And so you want to go into that knowing that. Also, it begs the question as to, well, what level of detail is required in terms of what the government knows? So let's say you have a line item in your incurred cost submission for a certain cost. Well, the allowability of certain costs is only dependent on what the contract says, right? So you can have a cost that's allowable under one contract and unallowable under another. For example, other direct costs. It might be an allowable ODC cost under one contract, unallowable under another. Well, the government doesn't know that until they audit and they look at the contract and they look at the costs and they pair the two together. So I could see the government making the argument that based on your incurred cost submission alone, they didn't know that, they couldn't know that, and therefore the claim does not accrue until they perform their audit. Now, I don't think it's fair for them to wait until they issue their audit report and their final decision. They knew or should have known when they get those documents in front of them and make the comparison. So I'd argue that would be sometime during their audit. But it does encourage contractors maybe to put more information in their incurred cost submission. Make sure it's robust. Make sure you have all the schedules. Seek outside help if you're not quite sure so that you don't keep restarting these statute of limitations, and that hopefully the government is on notice of what they need to be on notice of at the outset. The next case is the Sikorsky case, and this is a very significant decision in 2014. So in case law prior to this, it was thought that the Contract Disputes Act statute of limitation was a jurisdictional bar, which was great for contractors with all of these aging audits because that doesn't get you past go. Nope, your government, you're past 6 years, case dismissed. Unfortunately, what happened in this case was the issue was whether Sikorsky's allocation of its material overhead costs between government and non-government contracts was consistent with their cost accounting standards between 1999 and 2005. The contracting officer found they were non-compliant with cost accounting standard 418, and they claimed that Sikorsky owed them $65 million plus $15 million in interest. And they issued a final decision on December 11th of 2008. In looking at some Supreme Court jurisprudence, the court held that absent a clear statement that a rule is jurisdictional in the law or the regulation, it needs to be treated as non-jurisdictional. So they looked at the jurisprudence surrounding the Contract Disputes Act, and they found that there is no special characteristic to warrant an exception to the general rule for the Contract Disputes Act. So they held it is not jurisdictional. It is no longer a basis to seek a dismissal of the case and stop it in its tracks. It is instead an affirmative defense that you raise to the government. So what does this mean? This means that you can raise it to the contracting officer, you raise it in your case, but it just doesn't stop the case in its tracks. So what does this mean? This means that DCAA's audit backlog combined with the statute of limitations has really created some interesting issues for contractors. There's one more case that I want to mention too that didn't make it to the slides. It's fairly recent. It's May 2016. This is the Kellogg Brown and Root Services v. Murphy. And for those who want to look it up, it's 823 F3D 622. In this case, the contractor had a 2012 Contract Disputes Act claim to settle costs for a subcontractor termination for default. So basically what happened, Prime terminated for default the subcontract in July 2003. By September 2003, subcontractor was done performing the contract, but then there were some disputes between the Prime and the sub as to whether it was a legitimate termination for default. Based on a settlement agreement between the parties to resolve their dispute, the Prime agreed to convert the termination for default to a termination for convenience, which then allowed the subcontractors to submit a termination settlement claim as to what costs they incurred resulting from the termination. In August 2006, the subcontractor submitted the claim for their costs, and then some more litigation ensued. Eventually, the prime contractor submitted the subcontractor's claim to the government and certified it once they had a good number. So the question really became, when is quantum really fixed for the purpose of a claim accrual? Should it have, for this Contract Disputes Act, should that statute of limitations started running when the subcontractor stopped performing work in September of 2003, or when the prime contractor submitted that claim to the government based on the subcontractor's actual costs later on? The board held the claim accrued in September 2003 when performance ceased, and the Federal Circuit disagreed. They reversed and held the claim could not accrue until the claimant can assert a sum certain, which is when the subcontractor first presented the claim to the prime contractor in August of 2006, and therefore it was timely. Okay, well, wait a second. Now we're saying that the claim doesn't accrue until you fix the sum certain. So this was good for the prime contractor, and hopefully this is just in the prime-sub relationship, because hopefully the court realized that when you're a prime contractor, you can't submit something to the government unless you know what the subcontractor's costs are. However, but let's take this out. What if the government decides to apply this to the incurred cost proposals that are lingering? Well, we had just said, well, when they knew or should have known that they had a basis for a claim, but here they're saying it's when the sum is fixed, which the government doesn't know until after an audit. So hopefully this won't be expanded, but it was an interesting new case that I wanted to mention. So that said, contractors need to be aware of the statute of limitations issues, and I can't stress it enough. If you're going to resubmit your incurred cost proposal, think through the statute of limitations before you do so, especially if the statute is close to expiring. You can use this argument when negotiating with your contracting officer or the administrative contracting officer. Raise the statute of limitations issue if it works in your defense. Again, it might not stop it in its tracks, but I've seen it help the parties reach a quicker resolution because the government doesn't really want to litigate this, I think, any more than we do. And the big issue is, will the restriction on DCAA's audit of civilian agency contracts be lifted? I think that it's really causing an issue. Not all agencies have the sophistication and the ability to perform the audits themselves. And if anything else, for those contracts, it's just now creating a further backlog when they probably were already backlogged. So with that, are there any questions about the DCAA topic? Bobby. The question is, what non-DOD agencies have we seen doing their own audits? I've actually not. I've seen the audit stopped waiting for DCAA to come back on board, is what I've seen. Yep. Sure. The mention was about the slide not mentioning when we talked about the audit process, the entrance conference, which is when they first come in and really set the scope for the audit. And you can really focus that meeting on when you're talking about when you're limiting what documents you're going to produce and figure out what you need to do that. You know, I don't know if it's always in person. Sometimes it's on the phone, but it's that's initial meeting to really set the scope. Yes? The question was whether audit interviews can be recorded. And I don't know if the question is from the government standpoint or the contractor standpoint. My recommendation is not to, if you're the contractor, not asked to record them. And if the government asked you, I think it would be a little odd, and I would probably say no. I know contractors tend to really like to have things recorded when they meet with the government. Let me tell you, it's going to serve to hurt you more than it does to benefit you, probably. So I would not recommend that either party record it. But if you do, it needs to be, in most states, with both consent. Not every state, it depends. But most states, both party consent. The question is, what can contractors do, or what authority can they rely on to really push DCAA auditors to give them the final audit report? I don't have a citation off the top of my head, but I'd have to look through the DCAM and the FAR and the DFAR and see if there's anything in there. Also, the policy guidance. A lot of those documents are working for the government's favor, so I don't know if it really is expressly in there, but I haven't seen anything that says that they can't provide it to you. So sometimes it's the lack of something that says they can't give it to you. There is sometimes, I know, issues with prime sub, where if the government audits a subcontractor, the prime won't necessarily get a copy of the audit report, which most subcontractors appreciate. But I haven't seen any authority that, so I'd have to look into that. The question was, if you want DCAA to come in and audit you, you know, how long should you have everything in place before they do? And I'm assuming, because most people don't want DCAA to audit them, it's to get an approved accounting system to be eligible. Okay. So, you know, in my experience, if you call up DCAA and ask for them to come in and audit, that's not going to happen. Really what it is, it's in conjunction with a specific proposal where you have the accounting system in place, and then the contracting officer will ask them to vet your accounting system in order for you to be eligible for the award, which does create a chicken or egg situation because some solicitations require you to have a DCAA-approved accounting system beforehand. But maybe even during that proposal phase, they can try to push to get DCAA in there. So that said, I don't really have a guidepost of how long. I mean, you're going to have something that they can see that it's working. I don't think there's a magic number. I think a year would be great to be able to show that whatever your estimated provisional rates are as compared to your actual rates, that they're in line, that they're consistent. That would be helpful. Anything else? Okay. Well, feel free, obviously, during the break, we'll have a chance for questions.